Floyd, if we may, I think, Will, the accusations he just made about the line and basically.
Oh, there's a motion coming tomorrow.
Is out of line.
Okay. You'll see the motion tomorrow.
It's my turn.
Go ahead.
You do a pretty good job of talking over everybody. Now it's our turn to talk.
Go ahead, Tom.
Okay.
All right, let me go ahead, finish.
So what I'm saying is for him to make those accusations and to make the accusations about Mr. Neale, about lying, which insinuates our firm, his firm, is guilty of lying, is way out of line. He can file all the motions he wants to and say all he wants to, but it's out of line, and I want it on record that he's out of line.
I want it on record that the motion I'm going to file tomorrow.
A couple of things I wanted to cover. Is the production of the credit card information still disputed? That hasn't been worked out.
No.
All right, and I received the proposed order. Let me ask you this, for you folks on the Zoom, I'm referring to Colt's letter, June 8, addressed to me in the Wren case, all the cases, and he enclosed a proposed order for the production of bank card statements. Oh, there you are. I offered to wait for you. We didn't know if you were coming. You're mediating here today?
Hey, well, no, they said last time.
Oh, you were in Wall's case.
Right.
Yeah.
Yeah, I think I've done.
All right, so I just opened up, Will, the issue on the bank cards. I'm looking at the Nevada Beverage proposed order. And let me kind of go through the elements. I know we have a dispute here, and I hope we don't need more briefing of me just to kick out an order. But a couple of things, let me go through the items in the proposed order from Nevada Beverage. First of all, is there any objection to the 4-month period? That was the plaintiff expert testimony, right?
Well, no. All he said was 4 months is the median latency period for all generally applicable DILI. But it's not like anything within 4 months could be an alternative cause of their liver hepatitis or liver failure.
That's what he said.
The expert,
He said the average is 4 months, could be 4 months, right? He didn't say 2 months, he said 4. So what would I limit it to if the expert said the latency period could be 4 months?
well, it's not the time period that really you need a limitation for. It's the substance, the exposure. If there's something that can cause liver failure that these people consumed, and there's information that...
No, I'm agreeing with you. I think it has to be 4 months. I think it has to be 4 months. What would be my justification for, we'll get to the what they have to produce, but what would be my justification for limiting it to less than 4 months? The plaintiff expert said it could be 4 months. I didn't read the whole deposition. I got quotes, so if I'm wrong, let me know.
Yeah, I mean, I just think is there something in there that they started consuming within 4 months that, well, I guess it's just it's an irrelevant point. It's what did they consume, and what within 4 months or 8 months or 10 months or 1 month of the credit card statements is going to have any bearing on that issue. We're not trying to preclude them from discovering any information. And if there's something that they consumed, that there's a reason to believe they consumed, like it's in the medical records or we disclosed it, and there's information in those.
But how does an adverse party check that? They don't have to rely totally on you. How does an adverse party, maybe conduct a little more discovery or something beyond what a client told you, just to investigate it, some of these claims are pretty serious, so.
Yeah, they've got the medical records. I mean, the doctors, they didn't know anything about real water, so they were exploring any possible alternative cause. That's why you see so much information in the medical records about supplements. So if there's something in the medical records that tees off an inquiry, then maybe it's not such a fishing expedition. But right now, it's just a fishing expedition. But more importantly, I think it's just harassment. They want us to go back to all the plaintiffs and say, oh, you've got to give 4 months of bank records. There's some plaintiffs who aren't going to like that, okay? And I understand that. I wouldn't want to give 4 months of my bank records for some kind of fishing expedition. It's not just bank records, it's all their credit cards, everything they want. It's just, so they don't even have a basis for going in there. If they can come to you and say, hey, this person in the medical records purchased supplements, or the person in the interrogatories purchased supplements. If they're purchasing supplements, we say so, okay? Then maybe they have a basis for it in that particular case asking for the bank records. But just a general, let's go fishing through everyone's bank records for 4 months, I just don't see the justification for that. Like I said, if it's limited to a case-by-case basis,
For the 4 topics, there are multiple parts to the topics. For the 4 topics that they covered in the proposed Nevada Beverage order, which was food and beverages, groceries, alcohol, prescription, homeopathic, I don't know what treatment would be, that's pretty vague, and equipment would be, but herbal remedies and dietary supplements. So is it the plaintiff's position that between what the parties told you and what the parties told the doctor, that's all they need to investigate?
What the parties told us, you mean when we put in the fact sheets
Yes,
and what's in the doctor's report?
yes.
Yeah, I think that's all they need to investigate, because the medical records don't show any potential alternative cost. Why should we just be, okay, so let's take the alcohol case. So they
Is there some reason you point to me when you say that?
Okay, well, so let's say someone was drinking 1 beer every month for 4 months, okay? Why is that relevant? There's no doctor in America that's gonna say that causes severe liver injury, or at least I haven't seen one yet, okay? So why is that relevant?
And more importantly, what is in the bank records is gonna show that. I mean, it's not gonna say, oh, I bought 1 beer
Lee's
today.
discount liquor?
Yeah, but, okay, then they go subpoena Lee's Discount Liquor to see what was purchased from that location on that instance. And then how do we know that they purchased alcohol and drank it for themselves, or as opposed to their family member, or as opposed to a party or a friend? I mean,
No, that's the problem I have with the purchases. But I'm troubled by the fact that in a case of this magnitude, the defense is required, as far as finding alternate liver condition problems, that they're limited to the fact sheet that your clients told you what to put on them, and to the medical records which report what the client told the doctor. I mean, it's all limited to one thing, the plaintiff's version.
The doctor is not the plaintiff's version. These doctors are out there trying to find the causes. And since they didn't know about real water, they're considering everything under the sun. There's comments in all the plaintiff's fact sheets about, did you use alcohol or not? The doctors are asking these questions.
They
There's no
tested for
evidence.
acetaminophen. Their levels of acetaminophen, to see if it was potential acetaminophen. They ask them about their supplement use, and they list all the
Well,
supplements.
that's what I need to know. What inquiry do these doctors make, since they didn't know the real water might have been a cause? What inquiry do they make of these patients, just generically? I know there's a lot of them, but what do they ask them?
They ask them if they've ever used alcohol. Alcohol is a number one
Yeah,
thing
sure.
that they explore, okay? And so if there's nothing about alcohol in the medical records, there's no basis to look for alcohol purchasers. And then most of them ask about supplements. I'm not gonna say all of them do, but most of them explore the supplement issue. And then they look for any potential other alternative cause, family
Prescription
history.
medication.
Yeah, the acidic, Tylenol, we call it, okay? So that's all in the medical records, because the doctors are trying to find the cause. They're not just, and they're talking to the patient contemporaneously. There's no lawsuit present, so to suggest that that we're hiding information from the doctors when we don't even know about a potential real water lawsuit, because most of these cases are before the announcement in March that there's an outbreak. So I just, and what I really object to is the chilling effect this is gonna have. So now I gotta go to 70 plaintiffs and say, hey, we've gotta give 4 months worth of bank records, credit card records, everything you've used. And well, why is that? Oh, well, defendants want a fishing expedition, they want to look for alternative causes. I just don't, that's just a real burdensome thing to do.
And look at Gallagher. That's exactly what we're doing in Gallagher, which is set for trial September 5th. We've disclosed all the medical records. There's everything they examined for each individual plaintiff is in there. They looked at all possibilities because they did not know what was causing this potentially. They didn't know about real water. We did fact sheets. We disclosed all supplements they were taking to the best of their recollection. So you have the medical records where they say these same things. You have the fact sheets to the best of their recollection. They were asked about them in depositions. There was some stuff that we further investigated from purchase records with the store we had. So we gave credit card information. We gave dates to say, hey, this is when they purchased at this particular store. We looked at all that stuff, and it wasn't this broad fishing expedition to say we need to look at every grocery purchase that you made in the last 4 months or every restaurant that you ate at. The experts that the defendants retained said, hey, these are potential causes of liver failure, and then they, and evaluated them in relation to the information that we've produced and have agreed to produce and are more than willing to produce. And it's the same thing here. They have all that information. If there's follow-up information or if they have reason to believe that something's insufficient or they were, taking something else, they have depositions. They can ask us for it. If there's a reasonable basis for us to provide it or the information can provide relevant information potentially, we'll provide it. And if we don't, they can come back to you and say, this is why we need this specific information, and we can have a discussion about it and rule on something specific, which is exactly what our proposed order says. It's not that they can't have any of this information ever, just you have to state a reason why, not just everything for everyone, when 95% of this stuff couldn't even possibly be a plausible cause of the liver injury. I mean, what's their grocery, the place they shop for groceries going to tell them? Even if you go to the grocery, get the subpoena the grocery store, get the itemized receipts or the purchases from that. I mean, what reason is there to believe that information is going to provide an alternative cause? I mean,
when they fill out the fact sheets, I've seen a couple of lists of potential causes other than the real water allegation. And it's pretty extensive. I mean, it's a lot of medicine and a lot of other things.
Yeah, it turns into...
Do you go over that? Are the fact sheets, are the plaintiffs' firms going over that list, or are they just asking the parties, other than normal food and beverage, what do you use alcohol, what medicine you're taking? How are they interviewed?
We're asking the questions in the fact sheets. If they want to do additional fact sheets that's more heavily focused on supplements, they should propose that. That would be at least.
Be careful what you ask for. You want another round of fact sheets.
I don't, but I mean, we have, the problem here is none of this is going to be productive because let's use Dr. Tanner, for example. That's one of the experts in the first case, defense expert. So his testimony is that could have been this, could have been that, could have been this, could have been, Tylenol, could have been this, could have been this. And I said, well, is that going to change? And he's going to give that same testimony every single case because he doesn't think real water is, potentially a viable alternative. So it doesn't matter whether the plaintiff took alcohol. Doesn't matter whether they reported Tylenol use. Nothing matters to him. He's just going to say, could have been this, could have been that, could have been this, could have been that. That's going to be his opinion. So all we're really doing here is trying to, I think, just cudgel the plaintiffs to drop out of the case by saying, oh, there's this massively intrusive financial discovery going on. What are they looking for? Well,
Who wants to argue for the defense?
Hey, Floyd, I'm here. This is Colt on the Zoom, bar number 9,000, counsel for Nevada Beverage. A wise attorney once said, when you hear a lot of objections to form, you're getting to the good stuff. And I think that's where we are. This case is coordinated for a reason. I think the complexity, the number of plaintiffs, the number of parties, that's why we asked for that simplified order. That just seems to make more sense. It's something that should be produced. I think Dr. Hudson was deposed since we filed our motion, had the last hearing, and submitted our proposed order. I'm still happy with the 120 days, but I think he said something about 150 days at his deposition. I don't think this is a fishing expedition, and this court has already set a precedent of wide scope of discovery. All the emails, everything in real water servers, lists of non-party retailers. We want to get to the facts, and that's the point of discovery. It's not a fishing expedition. I submitted this specifically in the Wee case. There's a large discrepancy between what Daisy Wee told her medical providers and what we saw in both original and supplemental fact sheets. Discovery and medical records show that some people that are suffering from DILI, when they get to the point of liver failure or hepatic encephalopathy, if I even said that remotely close, are having brain fog, cognitive issues. They can't remember. Their doctors are asking them questions. They can't remember. They're sick. Some of these people can't go back and say exactly what supplements. And I'm frankly more concerned about supplements than alcohol. The alcohol, it shows up in the medical records, and there's a number of plaintiffs that were heavy drinkers. Supplements are not regulated by the FDA. Dr. Hudson testified that there's vast quality differences, even in something, again, Eric brought up the Gallagher. I think there's one plaintiff in there. I'm not a defendant in that case, but Belsky and the Kratom tea. Dr. Hudson said, well, we don't know how much kratom is in the kratom tea. There can be foreign objects, other things that can cause issues. So the purity levels are highly questionable. So it's important for the defendants to know what brand, going back to Daisy Wee, what brands of all of these supplements. She was adamant telling her doctor, look, that COVID was here, and she took a number of supplements in an attempt to be safe and try to prevent herself from getting ill. She can't remember that. We've received 0 receipts, 0 pictures of bottles, 0 samples of bottles. This is going back to 2020. The bank records have that, and that's very important. I don't think the plaintiffs can artificially limit discovery, which seems to presuppose causation. They only want to show their purchases of real water and nothing else, and that's out of balance, and that's not fair. We want to see what other supplements. A lot of this was on mail order. I thought we had pinned this down at the last hearing, and it was just boiling down the competing orders. I was surprised at plaintiff's proposed order, which seemed to have denied our motion, when it was my understanding the special master had granted it at the last hearing. So we narrowly tailored, and I think that you had read those 4 points from our proposed order. We just narrowly tailored what needed to be unredacted on those 4 months of statements. If they went to a movie, I don't care. If they did something that is private and it does not involve consumption of a potential hepatotoxin, they can redact that, throw that on a privilege log. I don't care. But supplements, a lot of these are mail order. It's not like they're going to a mainstream retailer and getting these. There's a lot of like I said, it's unregulated. They can get it anywhere. And we would like to know and want to be able to show our experts to get that.
Well, first of all, kratom is not regulated. There was a law passed in the state in 2016 that prohibits kratom from having contaminants in it. So you know, they are asserting that someone's violating the law in the state. And this is the whole problem, this theoretical thing. Oh, yeah, they took this drug that's really not the kratom. Kratom has some theoretical contaminant in it, and we don't know that for sure because we don't know what kind of kratom. It's all speculation. That's what Dr. Tenner did. You know, could be this, could be that, could be this, could be this. And I asked him specifically, is it going to change your opinion in any one of these cases if we prove this, that, or the other? Oh no, because it could have been that. You know, if you eliminate this, could have been it, could have been that. It's not going to change his opinion in any one of the cases. But the problem here is basically they want us to go hire 6 more paralegals to go to 70 plaintiffs, get 4 months worth. If it was just one bank for each plaintiff, which, you know, we keep saying bank records, it's not. They want us to go back and get every credit card the plaintiff used, you know, chase all that information down. You know, it's 2023 now, go back to 2019 and 18, if that's even possible in some of these cases. I just think that is a huge burden to put on somebody for wild speculation. The Creighton's the best example, okay? He is speculating that suppliers in this state violated a state law and sold contaminated kratom. Okay, where is the basis for that? All right, where's the basis for that? You know, and the Tylenol thing. I mean, so they're going to say, oh, well, they bought 1 bottle of Tylenol at Smith's in 2017. So Dr. Tanner's going to say, could have been. That's where this leads. All right. So we're going to go through all this work to get to the same place anyway, because it doesn't matter what they took. Then they're going to turn around and say, well, they could have bought it for cash, so they could have still bought Tylenol. You know, could have been. That's where this leads. Leads nowhere except a big make-work project for the plaintiffs. And that's why I think there's got to be a better way to go. You know, if he's got something like the Wee case, where he thinks that in the Wee case that there's evidence of a specific substance, you know, they should ask for supplemental discovery in the Wee case, all right? They shouldn't go every single case. I mean, like take the 2 Williams kids, for example. These are twins. They're, I can't remember, 3 or 4. You know, why are we providing bank records for them, all right? I mean, they're not taking alcohol. They're not taking these other supplements. You know, this is just a massive fishing expedition for most of the cases. If there's this case-specific case like we, you know, let them make a request in that case. You know, I can understand that. But to do a blanket order, I just don't think that's appropriate.
Hey, Floyd, one thing that I don't think Eric touched on or Will touched on, and I was the one defending that Dr. Hudson deposition in West Virginia. I have not heard anyone mention a particular supplement other than turmeric and kratom that even would have any impact on liver function. So are they going to ask about supplements for vitamin C, vitamin D, vitamin E? I mean, it makes no sense. At the very least, they should show some kind of proffer when you look at proportionality in terms of discovery. Tell us what supplements have any impact on liver function before you start having us chase down records for every supplement they may or may not have purchased for their household, not even themselves. So hold on a second, Scott. I'll be done in a couple of seconds. It makes no sense for us to have to chase down records for all of these plaintiffs for supplements that they may or may not have taken, for supplements that may have no impact on liver function. And so I was, you and I have done this dance many times, well, we've done it with everybody else around the room. I'm thinking of all the defense cases I have and how often I don't get bank records. A car accident, you're relying on depositions, written discovery, and medical records. And if there's anything else that caused that neck or back injury, typically you find it out of those 3 things. You don't get to get someone's personal bank statements to determine maybe they went to a surgical center or somewhere else. Maybe they paid for some medical bills that we don't see here. Maybe they have a separate medical provider that's not listed here. This is what you typically deal with, and that's all we're dealing with here in addition to fact sheets. So I don't know how you start this. What I would agree with Will, it's a fishing expedition to chase down every supplement that may have no impact whatsoever in liver function, and there's no expert that they have that identified additional supplements that may affect liver function, something that you would want to chase down.
And how far back do the fact sheets go on supplements and things like that? I don't remember.
Good question.
They ask about the supplements they were taking for the time period leading up to when they got sick.
at the time of symptoms, Floyd, is the subtle question.
Thanks, Jim. I'm sorry, what'd you say, Jim?
Floyd, the question on the fact sheet reads, at the time of the onset of your symptoms, were you taking any prescription drugs, over-the-counter meds, vitamins, or supplements? It's very narrowly tailored, and we absolutely need an order. Mr. Belsky in the Gallagher case, he's a Kratom user. He says he does it 2 to 3 days. He buys it on the internet. It's not a fishing expedition. He said that under oath in his deposition. He said it on his fact sheet. Then we followed up with discovery answers. And you know what we got, Floyd, because we came and complained to you. We got objections that said, we've already answered your fact sheet, go away. And we haven't got a ruling. This is a one-way street, and it's been this way for years now. It's got to change. We have chased down every single credit card transaction that Mr. Belsky has asked us to chase down at Whole Foods, looking for some elusive real water purchase. It's hard, Will, you're right. But we did it because that's what discovery requires. All we're asking for here is the same two-way street. He says he does kratom. Everybody agrees kratom can cause liver injuries. Why are we not entitled to find out how often he's going on the internet and ordering kratom from a smoke shop? This is simple.
Well, let me kind of intervene in this, because we did provide that information.
That's how they got it.
They asked us to, that's how they know he was taking kratom. It's in his medical records, it's in his fact sheet. They asked him about it in his deposition. They asked us to go back in his credit cards to see if there are any purchase records where he bought kratom. We did that. We went back, and I don't have a precise recollection. I think he had a prior credit card that was canceled that we weren't able to get the credit card receipts for, so we didn't have any proof of purchase in the credit card statements he had. And we told him that. We tried. We gave him the information, and if we had found it, we would have given it to him. He says where he bought it. He bought it online on occasions. He bought it in smoke shops on occasions. They have all this information. Their experts rely on it. It's their opinion that kratom was the cause. It's the battle of the experts. There's no additional discovery that exists on this that we have not provided them. And that's all we're saying should be with the Nevada Beverage request. If they want information on the supplements that are disclosed, or if they have a reason to believe that there's supplements that haven't been disclosed, we'll work with them and provide that information. And if we ever get to a point where they think we're not providing appropriate information, we can bring any disputes to you that's specific, not give us every credit card transaction of every person for 4 months. There's no expert affidavit that said this grocery list is going to provide any information on the cause of the liver injuries in these cases. I don't even know if Nevada Beverage has an expert, or if they're just coming up with this on their own.
Yeah, and I don't think, the statement that was just made that defendants have worked so diligently going back through their records, that's really a crock. Last night, after denying for 6 months that they had any written records that say Mr. Hale purchased real water from Whole Foods, for 6 months they've said that. This man said on the record during Mr. Haley's deposition that the written records prove you did not buy at Whole Foods. This is the false representation he made. Last night, after all the experts have been deposed, after Mr. Hale was deposed, the day before the motion to eliminate are due, last night for the very first time they produced a record from Whole Foods showing that Mr. Hale bought real water. Okay, so this is a complete crock that they have gone through this extensive thing. And now let's turn to Mr. Belsky. We've had an outstanding request for Belsky records for 6 months that they have not yet produced. Okay, they produce what they want to produce, and I know this isn't before you, but they aren't even producing the original Whole Foods records. They make these attorney Excel fact sheets that purport to say the purchases that they really don't. Okay, this is an attorney-driven thing, and we know it's attorney-driven because we looked at the metadata, and it says modified by Joan Anderson. So they've got the attorneys cooking up business records, and that's what they're giving to us, okay? They're not giving us the real Whole Foods records, and then they're lying about what the records say in the deposition, like I just said. This man represented to a witness that the records show absolutely no Whole Foods purchases, and last night they produced a record of a Whole Foods purchase. So to suggest that this is a one-way street, that is complete crock, okay? And I think what's really going on here is they're not happy with what they did with the fact sheet. He just said it, okay? Oh, we shouldn't have said, near the time of onset. We should have gone further back. That appears to be the problem. If they want to rewrite the fact sheet, fine. Come to you and say, hey, we need, in these cases, we need some supplemental information from for example, okay? Haley and Belsky, I don't know how they can complain, because Haley, I went and got all the turmeric bottles, made them available for inspection. They can count how many pills were gone. They don't want to do that because I can't remember if there's 4 or 6 bottles, but 3 or 4 of them are unopened. Another one has 8 missing, and another one has 30 missing. So it shows that the turmeric usage is really low. So in a case where there's a substance identified, we have gone above and beyond. I gave them the actual bottles that were remaining. Okay, there's no request for that. They don't want this information. So what they want to do is, like I've already said, launch this massive fishing expedition, make us hire 5 more paralegals, make us go back to 70 plaintiffs, and what for? Like Teddy said, the only 2 supplements that we've even heard anything about so far in the case is turmeric and kratom, and you just heard the previous counsel say they don't really care about alcohol. So what are we doing? Why are we doing this?
All right, do I have all the briefing from the parties? Because I'll go back and reread it. I've got the competing orders, but I had prior letters, we had prior argument. Do I have everything that you want to submit before I issue a ruling on this? Tell you what, I'll give you 1 week to submit any supplements.
Supplemental briefing.
Pardon me?
Supplemental briefing.
Can we have at least 10
Yeah,
days?
Not vitamins, Scott.
That's what I was making sure.
Supplemental briefing.
Well, we have to go to the judge today to do voir dire. We've got
Jury questionnaires.
Jury questionnaires. We got motion eliminates due.
What time do you want?
I just want at least 10 days.
2 weeks.
Okay, 2 weeks, fine.
Floyd, if we may, before we go on, I'd like to state categorically that I think Will, with his statements that he's just made, the accusations he just made about the line, and basically.
Oh, there's a motion coming tomorrow.
Is out of line.
Okay, you'll see the motion tomorrow.
It's my turn.
Go ahead.
You do a pretty good job of talking over everybody. Now it's our turn to talk.
Go ahead, talk.
All right, let me go ahead and finish.
So what I'm saying is for him to make those accusations and to make the accusations about Mr. Neale, about lying, which insinuates our firm, his firm, is guilty of lying, is way out of line. He can file all the motions he wants to and say all he wants to, but it's out of line, and I want it on record that he's out of line.
I want it on record that the motion I'm going to file tomorrow.
On that, it wouldn't be submitted to me anyway.
I understand.
The motion I file tomorrow will quote Mr. Neale from the Haley deposition, where he tells Haley that he has the records that prove that there was no purchase of Whole Foods. That will be in the motion
I
tomorrow.
don't need any more. That would have to be subject to the district court. That'd be beyond my. So.
And let me just say, Will, let's dial it back. As you know, there were separate requests from Haley. They all had different dates. Mr. Haley expanded the request after the deposition, looking for a real water purchase. We provided the expanded records, and lo and behold, we finally found one 500 milliliter bottle 17 months before he went to the hospital.
After he told Haley during the deposition that there was no proof of any real water purchase.
Argue that to the district
Well,
court. Mr. Neale, Mr. Neale, if you don't want to be cut out of the Zoom, please listen to me. I'm through hearing the argument on that. It's going to be submitted to the district court, not to me. And so we've got enough to talk about here. I'll allow all parties 2 weeks to submit any supplemental briefing on the arguments we just had regarding bank records and proof of purchases. This letter you just handed me from June 14th,
Yes, Mr. Neale will address that.
is it, you want me to read it now? Reread it now?
I'll wait for Mr. Neale.
Is it?
All right.
Is this it?
Is there a dispute regarding the deposition scheduling? I received a communication last night talking about the Dr. Dara, D-A-R-A deposition.
Yeah, what happened with Dr. Dara, again, she's the primary causation expert for United Natural Foods. We took her deposition, or tried to anyway. It was one of the most frustrating depositions I've ever taken, because I would ask questions like, are there any animal studies that support this proposition? She wouldn't answer the question, she would go off on a long-winded narrative, all right? So this deposition was one that I said during the deposition that we're gonna, when we resume this deposition, we're gonna have to have a special master monitor. There's some judicial official to make sure the answers are given. But anyway, so we go along with this way, and the deposition on video lasted something like 3 hours and 45 minutes, 350. It went longer, but that's how long the deposition actually lasted. And this was one of the longer depositions I've taken, and I try to be fast. I think, for example, the very next day I did their toxicologist, Dr. I can't remember his name, Dr. P. I did him in less than 3 hours. Okay, so I'm trying to be efficient in the deposition. But when I have a witness that won't answer a simple question and keeps going on these long rants over and over again, and I ask counsel to stop it, okay? Tell the director to answer the question. No, they loved it, all right? You know, but in any event, the only reason we stopped the deposition is because Scott said we have to go down to see the judge. We did have to go down to see the judge.
We did.
I can't remember what it was. We had a 2 o'clock appearance with the judge, so that's why the deposition stopped. The deposition didn't stop because I was done. I mean, how could I be done when she wasn't answering any questions? So we asked them to produce her for a continued deposition, to give us 3 dates for 2 hours each, and then our intent was to come back and see if you were available for those time periods and have a deposition to take her. Again, she is the principal causation expert they've hired in the case. She's the one that's going to say, and this is such an incredible opinion, it's almost laughable. She's going to say that Mr. Hale taking one gummy bear that has 200 milligrams of turmeric in it, one gummy bear alone could have caused his acute liver injury, put him in the hospital for 4 days. I mean, I think that is the most ridiculous expert opinion I've heard in a long time. And the very next day, their toxicologist said, oh, no, that could never happen. But this is the kind of person that we're deposing, you know?
So, let me back up. I haven't seen the depo, but, so the deposition lasted, what's Dr. Darrow's first name?
Lily.
Yeah. I think we
And
started.
she's the United Natural Foods.
Right,
She is.
And what,
I think we ran something like 5 hours from 9 to 2, but we took
Delivered
breaks.
doctor from California.
Right, so we were on, like I said, the record was 345 to 350. That's how long we asked questions.
I would categorize more like Will just didn't like her answers. I was there at the deposition, and I can understand why Will wouldn't like the answers, but just because he doesn't like something doesn't necessarily mean that she wasn't answering
I'd
everything.
be
She
more
may
than
not
happy-
like that
I'd
she
be
went
more
on for
than
quite a
happy-
while in her
let-
answers, but she answered all of the questions that he did pose her. We did take breaks during the deposition. I think both sides have been very good about an hour into it. We always try to take a break. I think that no one got heated as far as fisticuffs or threatening someone or doing something stupid like that. That never happened. I thought she presented well at her deposition as far as sitting
Well,
there.
do you oppose the
listening.
continuation of her deposition?
No, I don't, because Will is right, and I will agree. I brought it up. It was not my doing, though. It was the court's doing. Fair enough?
I didn't say you know.
He
But
said it was
I
the
did
court's
certainly bring it up at the deposition. Hey, we have to be, because the court has requested us to be in a hearing.
Can you give him 3 days of 2 hours?
I can't, it's not my.
It's not, may I, Floyd, I'm sorry, it's not Scott's witness, it's
It's
ours.
not my pertaining expert, but I'm trying to tell you what happened because I'm here and I know how sometimes it's hard to hear on the Zoom. And if I said something wrong, Jim, let me know.
Is there an objection to continuing Dr. Dara's deposition, working together and getting dates?
There it is, yes.
She's a medical, let me get this
You have-
straight. Just a minute. She's a medical expert in this case. She was deposed for less than a day by one attorney. The deposition ended because you all had a court hearing, and you opposed the deposition going forward?
Yes, but your factual predicates are not complete and incorrect. May I tell you the basis for our opposition?
Of course.
Thank you. So Floyd, the parties worked really hard scheduling this, and everybody cooperated. And I think we got an amazing amount done. I'm not sure how many expert depositions there were, but it was close to about 25 within 2 or 3 weeks. And nobody got everything he wanted. All of us were rushed. All of us gave up in-person depositions. We were double and triple stacking things. And we were very good about saying, this is how much time I need. What dates is your expert available? And who can cover it? And where's it going to be? And all of that got done, I think, to everyone's credit, without involving you at all. And every single deposition finished within its allotted time. And Dr. Dara's was set up no different. We were asked for dates for our experts. We were given a 4-hour budget. We said that email is included in that letter on page 2. Below is the anticipated time necessary to complete the deposition. Dr. Dara, 4 hours. We scheduled the deposition for June 1st. We changed the start time earlier to ensure we don't have a problem going the full 4 hours you requested. So we started at 9 a.m. We put her up. At 1 p.m., Dr. Dara had she had childcare. So at 1 p.m. on the record, on page 164, line 2, after the 4 hours expired, she says, if we're going to go on after 1, I really need to eat something. There's an exchange between Mr. Kemp and the doctor. There's discussion about how much longer it's going to take. And there's a resolution. And Mr. Kemp says, let's power through until 2 o'clock rather than reconvene another day. So we went an extra hour till 2 o'clock. Dr. Dara called her spouse to have him come pick up her child instead of her. She went and grabbed a power walk. And then Mr. Kemp asked a 5th hour of questions. It was the longest deposition of any of them. It was the only one that went above the allotted time. And finally at 2 o'clock, Scott said, hey, it was a meet and confer on the questionnaire that we had to go to. And Scott excused himself to do that. Mr. Kemp didn't even attend that. Mr. Pepperman did. He had 5 hours with this position. That's June 1st. Then discovery closes. And then after discovery closes, we get a letter saying, hey, we want more time. We want 2 more hours. And I want more time too. There's lots of questions I'd like to go back and ask their experts. But discovery's closed. We've already given Mr. Kemp an hour longer than he asked for. It's already come at some personal expense. Dr. Dara delayed a trip out of the country for the deposition as it was. And now's not the time to take a second bite at the apple. That's why we oppose the continuance.
estimate was 4 hours. And again, this witness didn't answer questions. It was the most ridiculous deposition. I would be more than happy to submit 5 examples to you of her refusing to answer questions and just going on these narratives. But in any event, we spent less than 4 hours in the deposition. We did not finish the deposition. We did not use the whole 4 hours. We even estimated. It was 345 or 350, I don't remember. I haven't counted out. And it was pretty obvious that we were going to have to continue this deposition. And the reason it stopped is because he was attending the deposition and he had to leave and go to some meeting. I didn't stop the deposition. I was more than happy to continue finishing it. Dr. Dara had made some kind of arrangement for her child care situation. I understood she had at least another hour. So to suggest, what they really don't want is they don't want this deposition to be properly taken where she has to answer some questions. And all I'm asking is 2 hours, okay? Now, the statement that was just made that every deposition finished and no deposition had to be continued, that is not a true statement. In the Babcock deposition, which is one of his experts, we didn't finish the deposition, or the deposition couldn't be finished because there was some issue about videos being produced. They came back and did the Babcock deposition. He was produced for a second time. I can't remember how many hours, 2 or 3 hours. The second Babcock. Yeah, so Babcock went, all told, what, 6 hours? So 5 at least, all right? So there's no justification. And, I have the right to take this deposition for more than 4 hours. That was just an estimate, okay? So to suggest now that there's some reason I can't take the deposition of their principal causation expert, this is their principal causation expert. This isn't an economist or someone who's got a marginal role in the lineup of experts. This is their principal causation expert. And like I've said 3 times, she wouldn't answer simple questions. When you get the transcript, I'll be more than happy to give you. You'll see that it's not that I didn't like the answer, it's I didn't get an answer. Are there animal studies that support the proposition that kratom is toxic? Oh, well, let's, that was the whole deposition, over and over and over again. And I'd be more than happy to
I want to see how that plays out in the train.
But anyway, and I could
I'm
ask.
going to allow the depot for an additional 2 hours. I'm not going to monitor it. I will read the transcript, and if I believe that the witness is not being responsive, then that witness is going to sit for another deposition, and I'll be there.
Floyd, I'll have the transcript to you today.
I don't need it today.
And I'll get it to you.
It's a ruling.
No, but I'm allowed, regardless of what happened in the previous, a major causation expert in this case, I'm going to allow another 2 hours. Even the federal rule would allow more than 4 hours. So I'm going to allow an additional 2 hours. If someone believes the witness isn't responsive or the witness has stalled the deposition during those 2 hours, I'll look at that transcript. Be glad to. I'll be glad to. But the fact that you had to leave for good reason, or an attorney had to leave for good reason, and just another 2 hours in this case for an expert is not unreasonable. Where is this deposition taken?
We did it on Zoom. It was a Zoom deposition.
Yeah, which is our
We're
office
not
in
asking
California.
anyone to travel.
Yeah, all right. Well, then even more so I'll allow it. Scott, would you do a Zoom deposition of an expert? Jim, does somebody sit in the office with her, or you're?
In this case, Floyd, that's what happened. We had a lawyer who happened to be in the area, so there was a lawyer with the witness. Yes.
So I'm going to allow the deposition to go by Zoom another 2 hours, and if necessary, and I'd rather have a root canal, and having grown up without fluoride, I've had a lot of them. I don't want to have to read the transcript to determine if the doctor has to sit from Judicial depot, but I will. So I trust counsel to visit with her about that and to help control the deposition if counsel believes it's necessary.
And I'm sure counsel will be on good behavior as well. Floyd, thank you.
Yeah. We'll have to have a break, but probably about half an hour in, like we always have. That's more for the court reporter, been doing that. But that's been standard. Everyone takes a break every hour.
I'm talking 2 hours of testimony.
Fair enough. I'm just letting you know that's what's been happening as standard, which I think has been good for the witnesses and the court reporter.
What's the issue? I couldn't find the information on this. What's the issue on the discovery deadlines of Martinez and Sharpa?
Yeah.
Okay, so in the Hunwardson case,
Yeah.
which is set for trial in January, we added a new party, NSF International. We added them several months ago, but they're just now getting in the case after motions to dismiss and things like that. They requested, as they're just coming in, an additional time to disclose experts, because the current expert disclosure deadline is July 17th, I believe. So we said, yeah, we understand, we're fine with more time, but we just won't agree to anything that causes the trial date to move at this point. And
Which judge has that case?
Kishner.
Is that Kishner?
Yes.
Yes,
Does she have Gallagher?
No.
that's Judge Williams. So NSF requested 60 days. We agreed to continue to July 5th, or the July 17th deadline to September 1st, or I'm sorry, September 15th, with the rebuttal deadline September 29th. And, you know, most of the experts have already been disclosed are going to be the same. There are going to be maybe some additional experts for case specific, and then the new parties may have some additional experts. But as you previously said, if the experts have been previously deposed, they're not being deposed again on the same opinions that are being disclosed. So we don't need a lot of time for the expert depositions, and we don't anticipate any issue with rebuttals because there's really no secrets at this point. And so that's why we came up with those dates. It still gives us, 6 weeks or,
The
plus or
trial
minus.
date is January 1.
January
4th might be right.
24th, I think.
Okay, well, it's January.
So basically, we just want to extend the expert disclosure deadlines, as I just stated, and leave everything else the same for now and go forward. NSF agreed with that. I heard from Real Water. Real Water agreed. I heard from Hanna. Hanna agreed.
Was there an objection?
No one's objected, but
Granted.
Sorry, Floyd, I got a new phone and it just, oh my God. Yes, there's emergency, that's the emergency. I can't do anything with it.
They certainly apologize.
Now it's doing something else.
You need to find a 13 or 14-year-old.
I do. Now it's
Clear on
calling
your
911.
okay.
No, if no one objects, would you just confirm that in writing?
Well, that's kind of been the issue, is I tried to confirm it, but I didn't receive responses from all the parties.
Yeah,
So I wanted to.
We have like 3 or 4 distributors in that case that really haven't been that active.
Did you send a letter, or what did you do?
We emailed everyone.
Confirming that was the agreement or the request?
We confirmed that we agreed, NSF requested this, we agreed to this, and asked for everyone to confirm their agreement or let us know if they have any objections.
I don't have an objection, it's approved.
I
think can I just say something for the defense on some of these folks?
When I don't have an objection, you need to
Can you-
add something for me?
Yeah, here it is real simple. We got this like 3 or 4 days ago. I just don't think there's enough time for people to evaluate, get back to clients, get back to carriers, and then come back and say, yeah, it's approved. If you'll give us another till next week, I think that's not unreasonable to say anyone who has to have an objection needs to have it sent over to the plaintiffs by, let's see.
What's the alternative if you have new experts and a new party? What's the alternative?
What is the alternative? That someone says, no, I need more time too for this or that or whatever it might be. NSF hasn't spoken on it yet, except for they agreed to it, but I don't think
They asked
If somebody wants more time, Scott, they just have to ask me.
Okay, that's,
I just wanna
that's
get
what
it
that's all we
moving.
needed to hear.
Yeah,
That's
no,
fine.
no.
I thought you were cutting it off right now. That was what I was worried
No,
about.
I'm allowing it, and if for some reason, with this many lawyers and scheduling and experts,
It's not easy.
I would be surprised if we hit all the deadlines.
I tried to ask for 3 more days to do MILs, and Will said no. So that's all I can tell
Because you said you didn't have it.
you. Mother.
You stood up.
So-
All right,
Floyd,
we have a court reporter. It's bad enough she has to listen to all of us on the relevant stuff.
Along those same lines, we also, not all parties, I haven't heard back from all parties, but some parties have agreed to move the expert disclosure deadlines in the Wren and Carrier case to match those same dates, so all the experts are looking at the cases at the same time and disclosures are matched up. I wanted to raise that too, in case anyone hasn't responded.
Same thing. We'll go by the date. I approved the dates you've suggested, but as I told Mr. Rasmussen, that, and I only refer to you that way when we have a court reporter.
Fair enough.
As I told Mr. Rasmussen, if somebody needs more time, first of all, if the council agree, you don't have to come to me. But if we have a dispute on that, somebody let me know, and we'll probably take care of it on a phone conference.
Floyd, this is Jonathan Fountain for NSF. I just want to confirm that the extension we've agreed to is for all defendants, not just NSF, on the expert disclosure and rebuttal deadline.
So agreed.
That was what you wrote.
Thank you, Mr. Fountain. What else?
That's it.
I have a question.
Am I supposed to set another hearing in a month? Or earlier if requested? Okay. I do think, despite some of the rather heated language today, considering the magnitude of this case, counsel have performed unbelievably. I've had less disputes on this case than cases involving 2 attorneys that don't really amount to much. You know, the counsel, I want to commend you. You've all done an excellent job in this case. You really have.
I thought the expert depots went pretty smoothly, considering we did 30 of them in 4 weeks.
You didn't call me. So anyway, if you need anything, let me know. If you need to get back on the phone, let me know. I'll set something up again in a month with Zoom.
Thank you, Floyd. Appreciate it.
Thanks, Floyd.
All right, thanks, everyone.
We're down here.